Every single year, American consumers lose over $8.8 billion to fraud, deceptive practices, and corporate violations, and the staggering truth is that most victims had legal protections available to them the entire time. They just never knew those protections existed. Welcome to Legal Eagle Brief. Today we are diving deep into consumer rights law, the body of federal and state legislation that sits between you and every company that has ever tried to take advantage of you. And by the end of this video, you are going to understand exactly what those rights are, how they actually work in practice, and the one legal concept that most people never use even though it could put real money back in your pocket today. We will cover the landmark laws that changed everything for ordinary people, the agencies that are supposed to enforce them, why enforcement often falls short, and the surprising power individual consumers actually have when they choose to fight back. There is one particular right that consumer protection attorneys consider their most powerful tool, and we will reveal exactly what that is before this video is done. Let us start with context. Consumer rights as a legal concept did not always exist. For most of recorded commercial history, the prevailing doctrine was something called caveat emptor, a Latin phrase meaning let the buyer beware. Under this framework, the burden fell entirely on you, the person handing over money. If you bought a product that was defective, misrepresented, or dangerous, that was largely your problem. Courts viewed commercial transactions as agreements between equals, which was a legal fiction that conveniently ignored massive power imbalances between giant corporations and individual buyers. The shift began in earnest in the early 20th century. The Pure Food and Drug Act of 1906 was one of the first major federal acknowledgments that consumers needed protection from sellers who would otherwise prioritize profit over safety. Upton Sinclair's book about the meatpacking industry had exposed conditions so appalling that public outrage created genuine political pressure for change. But that early legislation was narrow and enforcement was weak. The real transformation came during the 1960s and 1970s. A lawyer named Ralph Nader published Unsafe at Any Speed in 1965, a detailed takedown of the automobile industry's reckless disregard for vehicle safety. The book triggered congressional action, leading to the National Traffic and Motor Vehicle Safety Act of 1966. Then came a wave of additional legislation that fundamentally reshaped the legal relationship between companies and consumers. The Consumer Credit Protection Act, the Fair Credit Reporting Act, the Magnuson-Moss Warranty Act. Each one targeted a specific area where ordinary people were being systematically exploited. The Federal Trade Commission, originally created in 1914, was progressively given broader authority to police deceptive business practices. And in 2010, following the catastrophic financial crisis, Congress created an entirely new agency dedicated exclusively to consumer financial protection, the Consumer Financial Protection Bureau, better known as the CFPB. Within its first decade of existence, the CFPB returned over $17.5 billion to harmed consumers through enforcement actions. Now let us get into the specific laws that apply to your daily life right now. The Fair Credit Reporting Act, passed in 1970 and updated multiple times since, governs how consumer reporting agencies can collect, use, and share your financial information. This law gives you the right to access your credit report for free once every 12 months from each of the three major bureaus. It requires that inaccurate information be corrected. It limits how long negative information can remain on your report, generally 7 years for most negative items. And critically, it gives you the right to sue both credit bureaus and the businesses that report false information, with statutory damages available even if you cannot prove specific financial harm. The Fair Debt Collection Practices Act is another law with serious teeth. Debt collectors cannot call you before 8 in the morning or after 9 at night. They cannot call your workplace if you tell them to stop. They cannot use abusive, threatening, or obscene language. They must send you written verification of the debt if you request it within 30 days of their first contact. Violating any of these provisions can make the collector liable for up to $1,000 in statutory damages per lawsuit, plus your actual damages and attorney fees. This means attorneys often take these cases on contingency because the law makes it cost-effective to pursue. But here is what nobody talks about. The single most powerful tool in consumer law for most people is not found in any specific consumer statute. It is the implied warranty of merchantability under the Uniform Commercial Code, combined with your state's consumer protection statute. Nearly every state has a law prohibiting unfair or deceptive acts and practices in commerce, what lawyers call UDAP statutes. Many of these laws allow for treble damages, meaning a court can triple whatever amount you lost. Some include mandatory attorney fee shifting, meaning the losing company has to pay your legal costs. This creates real leverage even in disputes over relatively small dollar amounts. Consider a practical example. Suppose you purchase a television advertised as having specific performance features, and it consistently fails to deliver those features. Under common law contract principles, you might recover the price difference between what you paid and what the product was actually worth. But under many state UDAP statutes, you could potentially recover 3 times that amount plus attorney fees. That changes the calculation dramatically, both for you and for the company you are dealing with. The Truth in Lending Act, another foundational piece of consumer legislation, requires lenders to disclose the true cost of credit in a standardized way. Before this law existed, lenders could obscure interest rates through confusing fee structures and misleading payment schedules. Now, lenders must clearly disclose the annual percentage rate, the total amount you will pay over the life of the loan, and all associated fees. Violations can result in the borrower receiving statutory damages and even rescission rights in certain mortgage transactions, meaning the ability to void the loan entirely under specific circumstances. Product liability law adds another layer of protection. Under strict liability doctrine, a manufacturer can be held responsible for injuries caused by a defective product even if they were not negligent. You do not have to prove they were careless. You only have to prove the product was defective, the defect existed when it left their control, and the defect caused your injury. This doctrine has led to some of the largest verdicts in legal history and has driven safety improvements across virtually every product category imaginable. Now let us analyze what this all means practically. Consumer protection laws work best when people actually use them. The fundamental challenge is what legal scholars call the enforcement gap. Regulatory agencies like the FTC and CFPB have limited resources relative to the sheer volume of violations occurring across the economy. The law anticipates this problem by creating what are called private rights of action, the ability for individual consumers to sue on their own behalf without waiting for government enforcement. This is where individual empowerment becomes real. When a company violates your rights under the Fair Credit Reporting Act, the Fair Debt Collection Practices Act, or many other federal statutes, you can hire an attorney and sue. Because many of these laws include fee-shifting provisions requiring the defendant to pay your legal costs if you win, attorneys will often take meritorious cases without charging you upfront. You are not fighting a corporation alone. The law has already handed you structural advantages that most people never pick up. The most important takeaway here is this: consumer protection law is not theoretical. It is not abstract. It is a practical framework with real monetary consequences that sits dormant until you activate it. Every time you read a credit report, sign a loan document, respond to a debt collector, or purchase a product, these laws are the background operating system determining what rights you have. The companies you deal with know these laws extremely well. Now you do too. Understanding your rights is only the first step. Asserting them is where the actual protection happens. Document everything. Keep records of communications. Know which agency handles which type of complaint. Before you go, if you learned something valuable today, hit that like button right now. Subscribe to Legal Eagle Brief for a brand new video every single day. We will see you in the next one.